for a little bit about how important ideas are to journalists. And Shane, I want to ask you real quickly. You are a guy who does a lot of still photography, and you do videos as well.
Correct.
So, what kinds of things are you most concerned about as a freelancer who's out there in the middle of the night, and you're the only guy who shows up? Like, for instance, this picture right here. Tell us about that picture and how you got it.
Okay. This picture I took probably about 4 or 5 weeks ago in Aurora, Colorado. The gentleman who's wrapped in the Tyvek suit was a armed felon who held the police in a neighborhood at bay for the better part of a day in East Aurora. And I was there actually with my son, who's kind of apprenticing with me, and we were there late in the afternoon when this gentleman was taken into custody. And my son and I were the only ones who got any photographs or video of this guy being taken into custody.
How many other people were there to get pictures? The Denver Post?
There were no other representatives from the Denver media at that particular moment. They'd been out there earlier in the day, apparently, but everybody had, for whatever reason, left.
So you were the only one who got this really great picture.
Yeah, thank you.
So what happened to it? What did you do?
Actually, at least 1 or 2 of the TV stations used it with my permission, and I gave them permission to use it. Denver, as I was explaining to Carol prior to this panel and this meeting, is surprisingly not a real big what we call stringer market. And I think I mentioned to Carl as well. It's not a big freelance stringer market for the local affiliates. I think there's a lot of budgetary constraints. It's also kind of a culture. It's cultural here in Denver. But anyway, I have made some degree of money selling video and or stills to the local media over the years, but it's not a primary source of income for me.
Did you get paid for that picture?
I did not. I got a courtesy for that photo.
You just let them use it?
Yeah, for a courtesy,
How about this one? Now, here's a picture you guys might have all seen. Remember when the Uber driver shot his passenger last summer? Wasn't it in the summer?
Yeah, it was June 1st last year.
So Shane, the night crawler, is out there at 3 o'clock in the morning.
Yeah, with nothing better to do.
And he got this picture right here. That's the cab driver, and he is the only one. You and Daryl Orr, I think, were the only two out there, right?
Correct.
So tell
From
us
Channel
about
7.
that. You also got pictures. I mean, you know information that no one does because you're sitting there watching them give.
Right, it's
give
true.
mouth to
Both,
mouth
both.
to the passenger.
Yeah, both scanner information, which was available after the fact, but also, like you say, being a witness on the scene. So this photo actually, this was taken at about 3:30 in the morning, and I heard the call, and coincidentally, I was sitting next to Daryl Orr. We were conversing in the parking lot of the 7-Eleven that night at 3 in the morning, and we both heard the scanner call simultaneously, and it was a very unusual pronounced call because the dispatcher said, I have an individual on the phone who says he just shot somebody in his car, and he says he's an Uber driver. So we both skedaddled down there to I-25 and University where this took place, and Daryl was videotaping this, and I was taking stills of Mr. Hancock being taken into custody here for the alleged crime.
And of course, one of my first thoughts was he's an African American. That's the first time I realized he was an African American.
Right.
Of course, I was thinking, what's going on with the police there? Why is he being brought in?
Right.
Those were my first thoughts.
Right.
So it was great to have a picture.
Yeah, and it was also great just to be on scene, to be able to take some of it in with my own eyes and describe the scene to people afterwards who were interested in what occurred. And I was actually, by you, Karen, and by other people, I was actually asked to describe, almost interviewed about the scene as well as an eyewitness after the fact.
So your information, what was it worth to you?
It was worth a fair amount of money. I actually ended up making a few dollars out of the local media, but I had a national network pick up my stills for a videotape package that evening. So,
well, this might be a good chance to go into Steve Zansberg, you are a First Amendment attorney, aren't you, Steve? You
I am.
Basically, deal with the First Amendment.
Yes.
Well, tell us what this means when you talk about intellectual property and our ideas possibly being stolen. What does all that mean?
All right, so intellectual property is a subset of property, and it's a right that you have the right not to ideas. You were talking about protecting ideas, but with some exceptions, ideas for inventions, which are protected by patent, What we're talking about is protecting expression, the actual photographs that Shane and others take, or the actual reporting that you put out on the air, or Colorado Public Radio does. But the ideas that Mr. Hancock shot somebody at 3 a.m., an Uber driver, an African American, shot one of his passengers and was apprehended by the police, those are protected by the First Amendment, and they can't be copyrighted. The particular expression of how NBC News or whoever it is reports that story, once it's fixed in a tangible medium, that is subject to copyright. And the copyright is actually part of the Constitution as well. I defend the First Amendment by and large, but Congress has passed an act that was authorized by the U.S. Constitution to to incentivize the creation of creative works. And so copyright protects expression fixed in a tangible medium. And a tangible medium includes the radio airwaves and the broadcast airwaves and photography and art and sculpture and anything that's fixed in a tangible medium is protected as copyrighted the moment it's created.
Including the Wild West, AKA the internet.
Including the internet. Yeah, rule one is everything on the internet is not free. The fact that you can easily right-click and cut and paste something off the internet, and the fact that it's on the internet does not mean it's there for anyone's use. And I do have one, pretty good example of that. If you want to next slide, please. So this was a fellow, a professional photographer by the name of David Morrell, who found himself in Haiti when the earthquake hit. And he was the only professional photographer on the ground at the time, and for the next few days, because the the runways were destroyed. And so David Morrell posted a number of these photos on TwitPic of the devastation following the Haiti earthquake, and they were then distributed by Getty Images and Agence France Presse, and were on every newspaper and every news medium in the world. And they defended the case that Mr. Morrell brought based upon these 8 photographs by saying, well, they were on TwitPic, and the terms of TwitPic allows anyone to repost a TwitPic photo. But they lost on this case, and Carol, if you move to the next slide, a jury awarded Mr. Morrell for his 8 photographs $1.2 million in damages. That's $150,000 statutory damages per photo. Now, I know you don't license your photos for $150,000 a photo. No one does. But it gives you a sense of why it's a real concern for news media to use other people's works, particularly registered photographs, without permission. 8 photographs amounts to $1.2 million. So that's why our counsel is to be very concerned about professional photographs. So, and AFP and Getty defended, believing that the TwitPic license gave them permission, and the court ruled that it does not. It was permission to repost on TwitPic, but not to post on the front page of the New York Times.
Mm-hmm. Now, we're talking about pictures and we're talking about videos and things like that, but what about ideas? Because they're intangible. Carl, do you have any thoughts on your experience? Is there a time where one of your ideas was stolen, someone used it, or that you actually used it in your leadership roles with Channel 7 too, or Colorado Public Radio? Someone had an idea, you used it, but you didn't know it was theirs. These are very, very tough to snag down.
You've stumped me. I can't think of a tangible example because I try to work from a perspective of transparency. So I can speak in my instance, if somebody has an idea, it's the concept of what's the genesis of that idea, how is it going to then be developed, and you see it through from beginning to end. If you find out after the fact that maybe someone had a similar idea, that's where you have to kind of, again, there's a huge ethical, aspect to this as well. At Colorado Public Radio, an example, that I can give in terms of duplicated ideas. Recently, we had received an email from a listener. Her mother, she lives in Denver, her mother back in the 50s was one of the children who was tattooed or was part of a tattoo program to identify children by blood type, in the case they needed blood transfusions because of the war. So we did an interview with her. We had some audio from her mother. She talked about her experience, all of that type of thing. After we aired that segment, we got a listener email from someone else who said, well, gosh, I heard that story on a podcast. Why didn't you give them credit? And we're like, oh, we had no idea. And coincidentally, a week earlier, a podcast had done a similar story with somebody else, different person. We had no idea. So we responded to the listener saying, we had no idea. Thank you so much. And then we contacted the producers of that podcast to say, hey, we heard about your podcast. They happened to explore an additional angle that we had not, so we asked for permission to use their podcast. And the next day, we did a quick little follow-up to say, continuing the conversation, we happen to do the same subject matter, and here's another angle on it. And so, again, from a transparency point of view, it's all on the up and up. If you can, speak to and defend kind of your ideas and the genesis of that, I think that sincerity comes through. But in terms of the video and the photo aspect of things, and even you as a witness, the fact as a freelancer that you have an established relationship, I think can speak to the credibility factor, as opposed to not knowing necessarily the origin of information. But then with photos, my advice over the years with television especially is, if you can tell the story without needing that photo, then don't use it if you don't have permission. You err on the side of caution. So for instance, you could tell the Haiti earthquake story without using those 8 photos. You could tell the story of the Uber driver being arrested without using your photo.
That's true.
And so you need to start from the basis of what's necessary to tell the story. And then from there, you can build upon, oh, there's this great photo that maybe encapsulates that moment of the arrest. And we try to get a hold of you, try and get your permission, see if you'll license the photo, whatever that might be. And so from a quote-unquote competitive nature, there's that old adage that who's got it first and who's got the best video, who's got this, who's got that. I think in this day and age, that's less important than it is about being accurate and being, again, transparent about credit where credit's due.
How has Google, how's Google changed the world of being able to protect your ideas, do you think, Carl? For example, if I want to do a story on the Columbine survivors, I start Googling, and then I get 10 million stories, and then I take one of them.
What did we do before the internet? Exactly.
That line the rooms,
Right.
And it was, we had to rely on old archives, and we go to the library. But now,
Sure.
How's Google complicated all that? Maybe Steve might have a word on that as well.
Well, I mean, real quickly, I think it's just another means to an end. I mean, at the end of the day, we talk in the industry about, heck, when I started, you clipped to the newspaper to get story ideas. I mean, that's, the industry itself very much borrows from each other, and there is a competitive nature, but at the same time, everyone's going to do similar stories differently. So in the instance of the Columbine, anniversary as an example, it goes within reason that different news media will talk to perhaps the same survivor or
Over and over.
exactly, and it's up to that person whether or not they want to do interviews. The treatment of that story is where you start to get into infringement. If suddenly my story is written verbatim to someone else's story, that's problematic, but your approaches might be completely different, even though the interview subject is the same. But Google, I think, is more a means to an end for immediate access. But as we all know, you can't trust everything you see on the internet to begin with. It's just a starting point.
And you kind of hope that journalists would get past this Google thing and go on the sidewalk and go knock on some doors and start talking to people instead of just relying on the computers. That's where you get the good stories, is when you get out from behind the computer.
And that's still very true today. Absolutely, that's absolutely true.
That's where you're going to get your original stuff.
And your best stuff, whether or not it's
And your best
photos, video, or interviews.
Steve, did you have something? And then Shane?
Just on the other side, as opposed to the news gathering side that Google makes available so much information, we were talking before the panel began about technology making it so easy for people to protect their rights through going after infringers. So Google Images and TinEye and a number of other reverse image search platforms. If you have a URL, a site on the internet for like your photo of Mr. Hancock being arrested, you can put that address in and find every instance on the internet.
So it's a double-edged sword. Google is what you're saying.
Yeah, no, it makes it very easy for professional photographers, including yourself and your employees, because if they're employees, you own their copyright, to go after folks who are using material without permission. And at $150,000 a use, it's lucrative for a number of plaintiffs' lawyers who have made a very good profession going after folks and accepting multi-thousand-dollar settlements.
I feel that a lot of the current day argument goes back to the Napster days, to be honest with you. File sharing, quote unquote, on the internet. And I think one thing that I feel I'm up against, I've got 2 adult children, a millennial and a Generation Z. And I feel that one thing that we're up against is an industry with particularly I think the battery just died. Sorry about that. Technical difficulties. I wouldn't know about that. I'm a television cameraman. I've never had one of those. No, all I was going to say is that I think particularly with the younger generation as consumers, as media consumers, and also as content generators and creators, I think there's a lot of disinformation, misunderstanding about what's free, what's intellectual property. I think even defining intellectual property for particularly a younger generation, for the general public is hard, but for a younger generation who grew up very internet savvy, I think it's quite difficult because they are under the assumption that everything they click on a mobile device is theirs to use however they want for free. So I think part of it's an educational process too that we as creators need to address and put out there.
And well, and even for people who've been in the industry for a while, there are assumptions that get made that certain things are in the public domain, and they aren't always. So, for instance, there are photos of John Benet Ramsey that I believe are copyrighted. Mm-hmm. There are speeches, Martin Luther King Jr. speeches that are copyrighted. And so even though they're out there, and at some point copyrights might expire, you can't ever assume anything, even when you know that the video or photo might be quote unquote legitimate. Having said that, so many images are also not, they're not what they're purported to be, and so you just have to, again, it's a means to an end. You have to start, but then you have to do due diligence to track down who's the owner, YouTube, for instance. Half the things posted on YouTube, that's a general statement, that's probably not half, but things posted on YouTube are posted by people who don't own their original material, and so you can't just run with it and say, oh, I contacted so-and-so who posted this, they said I could use it.
Yeah, but the thing that runs rampant on YouTube that I've run into even personally, which Steve can totally address, is quote-unquote fair use.
Well, and again, that's where I would urge everyone to think fair use.
7 seconds, right? We can use 7 seconds
right.
of everything?
Right.
Is that right?
Yeah, how many people believe there's a 7-second rule or a 12-second rule?
That sounds right to me.
Don't raise your hand.
There is
Don't
none.
raise my hand.
No, there's no minimum amount that is de minimis use. And perhaps the most stark example is there's a case that went up to the U.S. Supreme Court, not involving sound or video, but involving Gerald Ford's autobiography, his memoir. And it was a multi-100-page tome, and one of the magazines broke the embargo, and in advance of the release of the book, excerpted a few hundred words of this tome in which Gerald Ford described his decision to pardon Richard Nixon. And so the publishers, HarperCollins, sued, I believe, The Nation magazine for stealing the heart of the work. And they took just the smallest amount of this 600-page tome, and the U.S. Supreme Court said it was not a fair use because the only thing anyone cared about in that book was to find out why Ford had, and the thought process behind the pardon of Richard Nixon.
So they pirated the goods. I mean, they stole the goods.
Yeah,
Treasure
they
chest.
destroyed the market for the underlying work. And so if you want to show the slide of the two videos, there's one video of Reginald Denny, just by way of example. So merely because you're using someone else's work, that's it. In news reporting and journalism is one of the protected uses for a copyrighted work to be fair use, but it's not a get out of copyright infringement free card. And so I have an article that you're welcome to read, and Jules is going to make available a web link to it that discusses these two cases in some depth. But two different uses, in fact, LA News Service that took the helicopter photography of the beating of Reginald Denny during the rioting after the, what's his name? Rodney King. Not guilty verdict for the officers. They used just a small, in one instance, less than 7 seconds of the video where Reginald Denny was taken from the truck and beaten with a brick. And that's the heart of the work. I mean, it was a 7-minute video. So there is no minimum amount of usage if you're stealing the very essence of the piece. And when I say stealing, that's where, I mean, I don't want to do a whole, continuing legal education seminar here, but copyright fair use is a 4-factor provision in the copyright code. And so one factor is the amount of the work you use, but there is no minimum requirement. Another is whether it's transformative, if it's being used for a purpose other than the original purpose. And if you're using someone's stock footage or a news photo to tell the news, that's the same purpose for which the photo was taken. If you're using it for parody or for some commentary, or if you're commenting on the fact of the footage itself, I argue that's the safest fair use, to say this video caused a change in race relations in the United States.
I'll tell you one thing, and we're going to go to the audience in just a second. I just want to tell you one thing, all of you who, if you're worried, when I was working for ABC on this missing mom down in Woodland Park, we were the only ones there for the arrest of the guy who's now in jail. And so my correspondent, who's great with an iPhone, had video that no one else had. He went in there into iMovie, put an ABC News bug on his own video, and tweeted it. And I'm like, how did you do that? So in other words, he solved his own problem in 5 minutes working on an iPhone. And I guess that's one solution, that if you can learn how to put your own bug on something.
Well, as much as of a problem as putting a bug on video can solve, but it can always be squeezed and it can be covered up,
Right.
and
Oh,
another
I see.
graphic can be
Well,
pasted over it.
It was the best thing we could do.
Correct. No, I agree. That's one of the only options we have for video, but there's a lot of ways around
People
that
can
as well.
squeeze that out, huh?
Well, and again, that gets back transparency with fair use. If Good Morning America has an exclusive interview with
Please say it's,
somebody,
yeah.
and you are going to argue you're going to use that as fair use, you don't crop it off. You put it in a TV box, and you are really deliberate about saying, Good Morning America interviewed this person, give credit
Yeah.
where credit's due. It may not take away all of the risk, but it shows that you're giving credit where credit's due, to say, we're using this under fair use, here's the audio, it's clearly fonted, it's in a squeeze box, even on a website. You show the whole website, and there's the photo, and
it's
TMZ
getting more
posted
accepted.
this.
Yeah.
Well,
I think it's getting more accepted.
again, it's a slippery slope,
It
because
is.
you still want you have to be purposeful with why you're using it. And the other thing I just wanted to bring up, one of the trends I noticed recently, I don't know if it's a trend or not, but it's the idea that a video does come out, it does go viral, and that's the new catchphrase. Oh, this video's gone viral, everyone starts using it. And it
Yeah.
seems as though there are services that then try to copyright it after the fact,
Gosh.
and try to get money for the person because it went viral and they didn't expect it to. And I think that's just another interesting facet or tangent to this issue of you know, what's the source of the video, and at some point does it become copyrighted, and where do you have to back off?
In
It's
addition to
happening
being-
faster than we can, happening faster than we can fix it.
It is, and in addition to being interesting, I think it's a horror show right now going on with, particularly with, we're up here as professional journalists, attorneys, professional journalists here in this room. We all have our point of view. It's going to be somewhat biased. It's going to lean towards the professional aspect of all this. But as I work in the news industry, and particularly the 24-hour cable news industry now, there is so much pressure to get video on the air so quickly that on these mass events, I mean the shootings and you know the catastrophic weather events and all these things that happen, people are just grabbing stuff so quickly off the internet that I think it's creating it's just creating a huge amount of speculation and problems for who owns this video. People are, you know, are tracking it back and giving courtesies, but like Carl was saying, it's hard to know where some of the stuff even originates. And I think that's a real scary new frontier for everybody. I think for professional journalists and broadcast organizations as well as consumers.
I want to take a question from the audience. We have Jacob Curtis sitting back there. You want to run the microphone over to Jacob there, who's a photojournalist for KMGH here in Denver?
Yeah, well, I think I had a question, but I think you might have answered it. But in the role of when you do have something that's big that goes on and putting a courtesy, how does that get around copyright? If there's something on, like if the Las Vegas shooting,
yeah, that was a great example.
Everyone was pulling Twitter, and you know, we're told, you know, you got to put the courtesy on there, and I guess that sort of solves some things, and you guys were just talking about viral videos, and it makes me think of one example where there was a blue whale bubble, or a whale bubble feeding in Alaska, and it was an amazing video, and there was 2 stations in Anchorage, and they licensed the video after the fact, so we bought, the station I was working for bought the video, the other station didn't. They had to play terrible quality. We played the HD. But anyways, my question is about courtesying, and how does that factor in with the squeeze box even too?
Steve, what do you think? I'd jump in first there.
Sure. Well, just legally, copyright infringement is a person suing for copyright infringement has to prove only 2 things. And it's really remarkable if you think about it. It's that they own the work. So anyone who takes a photograph, blue whale, iPhone photos of the shooting in Las Vegas, or 9 News owned all of the helicopter footage of Columbine that everyone was reusing this week, even though it was seized by the sheriff and used in the report. That's 9 News' copyrighted work. It's not available free of charge. So anyway, they just have to prove they own the work and that it was used without permission. That's it. It doesn't matter if it was used believing that they had permission, but they didn't. It's what we call a strict liability. You don't have to prove any sort of wrongful state of mind. Just, I own the work and you used it without permission. That's it. And so attribution, as you say, but we said it came from the Denver Post, it came from Shane, it came from wherever. That's not a defense. I own the work and you used it without permission. I don't care if you gave me credit. I don't care if you put all kinds of people onto my website by posting my URL and you brought me more traffic. I still can sue you for copyright infringement because you used my work without permission. So attribution is not a defense to copyright infringement.
That's scary for newsrooms, though, Carl. Like for your newsroom, how much time do you spend on worrying about that kind of thing?
Oh, well, I don't know that we spend time worrying on it. I just think we have to, we consider it, right? So I think with the idea of burning your logo on video, that's to show that it's your video. If it pops up elsewhere, then you can kind of say we're the source of that video. But the idea of just putting a courtesy, like a Chiron type courtesy on a photo or a video from YouTube, yeah, I mean, you need to get permission. And if you can't get permission, then don't use it. I mean, ultimately, that's my advice, and that's always been kind of the direction. And again, it gets back to how critical is it to show video of a whale or some kind of kicker kind of video. In the scheme of things, it's not. It might be a great element in a newscast, but it's not mission critical in terms of, to me, proving fair use. So you always err on the side of verifying. So even in radio, when we get somebody might tweet something or they might leave a comment, we'll call and ask, hey, can we use your comment on the air? Would you mind if we use your name and where you live in terms of a city? So-and-so from Denver, emailed us this. And better yet, would you mind if we recorded your audio, have you record on an iPhone, send us the audio clip, and we'll play your question on the air. Again, it gets back to the concept of transparency. If you have nothing to hide, and I get the whole thing about intent and all of that, notwithstanding, do your homework and make sure that what you're using is again, from the source, it's authentic, and you have permission to use it, and you save yourself a world of hurt, a world of headache. You avoid it.
We have a question from Dan Petty, our Denver Press Club president.
Hi. So we were talking a little bit before this about a personal experience of mine where a photo of mine has been used a lot, and if you do a reverse image search, there's like 30 million, I'm sorry.
Don't be a
copies
show off.
No, I didn't realize until somebody had actually tagged me on Instagram, because it was a personal friend who knew I had taken the photo, and somebody had taken the photo and put their own like Twitter handle on it, on the photo, and I never registered it for copyright. But my question is, this is, you have high profile cases like the Haiti case and others. Are any of you seeing any sense whatsoever that so it's one thing if a news organization does this. Like, I think increasingly, I can remember when I was an intern at the Denver Post, like just drilling into our reporters who, were blogging on their own, and Steve, you might have some background on some of this, drilling them and just, you cannot pull stuff from the internet, it's not free. But there's this whole other world of people who just have no knowledge of this whatsoever, and I'm curious, no interest. And I'm curious, are you seeing like a public shift in awareness about this? I mean, particularly like younger people who are maybe going through elementary school or middle school and maybe getting like an education about this, about digital literacy and copyright. Are you seeing any evidence of that? Like, in other words, is there any reason to hope that this will maybe go away?
I think there's always reason to hope, but like I stated earlier, I mean, I've got two great young adult children, and I think this situation is kind of a runaway freight train with the internet. I really do. I just think it's too big. It has too much momentum. There's just too much downhill speed with this to factor in right now. And I think some of these high-profile cases, like Steve has mentioned, I think create awareness probably more within the professional community, to be honest with you. But as far as the younger demographic, I think the mindset in general is, if it's on this device that I have in my pocket right here, if it's on this device, it's mine to use as I feel fit.
Yeah, and I think that, I forget, there are some statistics out there about how many images and music and videos on the internet are copyright infringement. Their estimates that it's over 90%. So I think it's safe to say that a very small percentage of online copyright infringement gives rise to a legal claim. And on both sides of that equation, it's people with significant money at stake. So an unregistered photograph can't be a basis for a copyright claim, and it can't give rise to statutory damages. So a lot of stuff that's on Facebook, the selfies and things that are not taken by professional photographers, that are not registered, are not going to be sued upon regardless of who uses them. And then on the other side is who's infringing. And so the reason why there's this cottage industry of people going after my clients, the news media, is because they have deep pockets and they have insurance companies behind them, and they're willing to pay to settle claims, whereas all the young kids who are borrowing stuff, they don't have any money to pay, so no one's going after them.
I had a college athlete who took a photo of mine, and it's a thing I noticed, who, I took a photo of a woman winning the NCAA cross-country championships, and, she put a little thing in the Instagram caption that said, photo credit and my handle, and, like, that's just the way that they do things. And, I'm not going to go sue her, but technically it's a copyright infringement.
Dr. Lloyd Cubbins, you had a question a little earlier.
Thanks a lot. I was looking at the statute, the time frame, because EchoStar, which is now a $22 billion company, at one time in Littleton had 3 employees on South Broadway. So we had a weekly. We did a story on one of their upcoming events, or it was a new venture for satellites. It's a pretty big deal to them. I think it was $10 million, which for 1994 was astounding. Long story short, they took verbatim the story, and I saw it in Pat Wiesner's Colorado Business, word for word. So my attorney says, okay, we got to sue Pat Wiesner. And, you know, we waited a couple of days. We made a phone call. He says, no, here's the press release. And it was from EchoStar to the general media. And since he was a big advertiser, well, you can guess we didn't do anything. But I come back to this as a point of when everything is ripped off by the subject, is there any protection?
Yeah, there is. I mean, you chose not to go after EchoStar there, but you know, for the reasons you said. But you did have a claim, and you know, it doesn't happen all that often. Every 4 years there are campaigns, and candidates are constantly republishing verbatim entire editorials from the Denver Post or the Gazette or wherever it is, and every 4 years I end up getting calls saying, "Can you write this candidate a letter saying you can use the headline, you can take a snippet of the piece, but you just can't copy the entire expressive work verbatim without permission. That's not a fair use." And so we do write those cease and desist letters. We don't sue these people to get, you know, statutory damages, but you do have to protect your intellectual property rights, and you can.
Is there a time frame involved in terms of harms or the number of years ago it was by?
Well, the statute of limitations for copyright infringement is 3 years. So 3 years after you become aware of the infringement.
This is our own personal question hour. We have John Insolin now.
Right. Well, I have a converse question. You know, you've been talking about it from the point of view of copyright, but Steve, I hadn't heard of that case against the nation on the Gerald Ford text, and what's left of fair use after that? I mean, it seems to me like if fair use was an island, it'd be a very tiny island now, because there have been lots of cases where journalists have pursued the advanced copies of books by presidents and excerpted at greater length than what you described, and were successfully able to claim fair use. It doesn't, from what you described, I don't think there's any fair use at this point.
All right, can we put up the 4 factors on the fair use? I mentioned them earlier. I probably should have. Yep, you went past it.
Is that it?
Nope, earlier. It's got red. Nope. Go back. It's actually the first of the slides in there. All right, so that's all right. So the 4 factors, and this is in the statute. It's a defense to copyright infringement. So notwithstanding that it was someone else owns it and it was used without permission, a defense is that you're allowed to use it under the fair use exemption. And so the purpose and character of the use is one of the factors, and that's where the transformative test comes up. Are you using it in a means for a different audience or in a different way than the intended use by the creator? The nature of the copyrighted work, the more artistic the copyrighted work you're borrowing from, the less likely it is to be a fair use. The amount and substantiality of the portion, so not just amount but substantiality, that's the heart of the work doctrine from Harper and Collins, and Harper and Row rather. And then effect of the use upon the potential market. And many people believe that's the most important factor. If you're using file footage to illustrate your story, and that's the basis for somebody to earn a licensing fee, And by the way, most photo use is 100% of the work. You don't usually use a small section of a photo. So photos are particularly dangerous. But the fair use defense still does exist. I mean, what happened in that case was that in advance of an embargo, when portions could be used and fair use could have been after the book was on the market for a period of time and had sold a good number of copies, then they, the nation could have fair used that same footage, same text. But because they did so in advance of publication, before it was even available to the public, they effectively destroyed the potential market for that book. And so that's really what that case stands for, is that it's not, that these are, first of all, these aren't the exclusive factors, they are in statute, but there's no one factor that's more important than the others. They're looked at in totality. And in this article that I'll pitch one more time, that I commend to you, I point out that the safest use of someone else's copyrighted work is to comment upon or criticize the existence of that work. So the example I give is a Columbine photo, since we're talking about Columbine. There was a photo taken by the high school photographer for the yearbook, and everyone has seen the photo of Klebold and Harris sitting next to each other in the stands among 600 classmates. But the photo that didn't run in the yearbook was of the two of them and a couple of colleagues pointing their fingers at the camera as if they were guns 2 weeks before the shooting. That, I argue, is a fair use, to comment on the existence of that photograph. And the same is true of a number of other instances where you could talk about the MLK speech, I Have a Dream speech, and use a very small snippet of it in a historical documentary about the 60s or about the civil rights movement. But you're right, that work is copyrighted, and the King estate is very aggressive at going after people who use that work just in total or to run minutes of it. So it depends upon this interplay of all these factors, but fair use does still exist, and in particular when you're commenting on or criticizing the existence of the copyrighted work as opposed to using it to illustrate your story. That's not fair use.
So another question in that same vein. This comes up a lot when I'm podcasting. I've taken a very stringent approach of using other people's music. I just don't. But sometimes I hear podcasts that are about a particular song. This is when Billie Holiday made this song, it changed everything. And people will play that song throughout, and it doesn't sound to me as if they went to the Billie Holiday estate to get it. Is there an exception if you are commenting on a piece of music?
Well, it's the same for any work of art, and I do think that that the second rule of thumb in my article is to use the minimum amount necessary to make your point. I have a colleague who runs a documentary clinic at UCLA who counsels to ask the producer, how much time do you need of this clip? And the producer will say, I only need 8 seconds. And you say, okay, then use 6. so that they're always using less than they claim they absolutely need. And the last thing you want to do is use more than you absolutely need. So yes, if you're doing a documentary on Billie Holiday or Sam Cooke's great classic that changed the course of the civil rights movement, yes, you're commenting on the existence of that work. It's well within the sweet spot as I describe it. But you still can't use all of it just for the purpose of entertaining your listeners. You have to comment on and point out what you're commenting on.
You know what, we're still talking about mostly about videos and still pictures and music, but what about ideas which are out there in the stratosphere? What if you have an idea that no one has, and you know that that's going to get you work, and you tell it to someone, and that person goes off and uses your idea? Do you have any recourse for something like that, or do you just kind of shrug your shoulders and move on? Because ideas you can't prove. I mean, it was a conversation we had between the two of us. I didn't text it to you. I didn't email it to you. We had the conversation, and here you are using it. How do you?
There are very few instances in the law where ideas per se are protected. So in the news business, CPR just ran a story about allegations of sexual misconduct inside Endarco a couple years back. And Bloomberg News ran the same story the same day. And they were independently working on it at the same time. And each of the stories are protected, the expression. But the idea and the investigation, and you counted another story where people are researching the same ideas. So there are, ideas can be protected, particularly with inventions, a patent.
Oh, with inventions, sure.
Yeah, inventions and things that are confidential and where people have a duty to maintain a secret. That idea, that secret can be protected mostly by contract, not by freestanding law. Ideas are, we want people to freely share ideas and not be held outside of a contract, a non-disclosure agreement, which is quite popular these days in Washington, D.C. But by and large, ideas aren't protectable. Now, in the copyright realm, and particularly in Hollywood, where they're creative ideas, more so than news ideas, there's some slippage there where a character in Gone with the Wind can't be used for a sequel or a prequel because it's a creative work and the character itself is protected as part of the author's work. But in terms of news ideas, I've got this great idea. Let's find a way to go into a medical marijuana establishment and pretend that I've got a card, or whatever it is, an undercover report, a sting operation. You really can't protect that idea.
So it's up to you to just not tell people.
Yeah.
Except the people who
Or
matter.
follow up the verbal conversation with an email to say, as we discussed, here's my idea, maybe.
My idea.
What about, hey, Steve, I've got a quick question. It's slightly off topic, but it's still more or less on track, and that is, what about people who say, well, they stole my style, for like a television show or for a news show or news open or a SAD or anything like that?
Like the Dateline guy that...
Yeah, well, whatever it might be, things that you associate with particular shows stylistically. Is there any protection offered for that?
There is another area of law called trademark and trade dress, where if it's your, and trade dress includes, the look and feel of a restaurant. Like there's a U.S. Supreme Court case including, it's not Taco Bell's, I can't remember, it's a Mexican-American chain, but just how they if you go into Starbucks, you wherever you go, you're in a Starbucks. And so if someone set up a competing coffee chain that mimicked or was extremely close to Starbucks, they would shut them down, and they could. And so there are protections for trademark and trade dress and style. The look of a Rolex watch isn't copyrighted, and it's not, the look of it isn't a patent either, but the folks who are doing knockoffs on Rolex and other famous brands, those are protectable ideas as a style of business, a way of presenting your product or goods and services. But a set, like a news set, Channel 7's news set, if Channel 9 were to suddenly remake itself and knock it off, I don't see that happening. It probably happens market to market, more so than within a market. And I question whether or not that would be a viable claim.
I'm going to close out the panel, but we're going to take a couple more questions. And I want to get some closing comments from you all, just kind of your takeaway from tonight. I think Dan has one last question.
Steve, I was just curious about what your feeling is about the Digital Millennium Copyright Act, which was passed in 1996. How you feel like it's held up, what changes, if any, would be made, and do you feel like there's any hope that that thing might be updated sometime in the future, in the very near future?
Yeah, so the Digital Millennium Copyright Act, or DMCA, really doesn't protect the infringer. It protects the intermediary. So it's for, if you're hosting a website, and it is digital, so it only applies online. It doesn't apply to broadcast. But if you're inviting people and allowing people to post works, say YouTube or Google, and they're posting copyright infringing works, you're, as the host of that work, you didn't post it, but you're merely hosting it, you are absolved of liability so long as you have, it's a notice and takedown regime where, and this is true of YouTube and a great number of other sites, where so long as the copyright owner can notify the host that that's my copyrighted work, you better take it down, and there's a formal form that has to be submitted, and there has to be a designated agent in the US Copyright Office to receive these notices, then if you as the host take that down and notify the person who posted it that you did so, the person who posted it can then come back and say, no, I have a license, I believe it's fair use, and you can repost it as the host and let them fight it out in court. But as the host, you're off the hook. And I think that that regime has worked very well. There's a similar regime, not for intellectual property, but for, it's called the Communications Decency Act, that relates to defamation and other claims, again, for hosting third-party content. And Congress in that act just absolved hosts of any liability for third-party posts so long as they didn't participate in the development of the offensive conduct. So I think both of those statutes have proven to be incredibly valuable to creating an extremely vibrant internet. Are they perfect? No. Are people's copyrighted works being used all the time, every day, without their permission? Yes. And I'm not so sure, given the younger generations, that both of those acts won't be tweaked as we go forward to try to correct matters. But I think if we didn't have both of those protections for third parties posting, the internet would not be what it is today.
Do we have any more questions from the audience before we call it a night? So Steve Zansberg, in case you didn't know, he has really been a blockbuster guy for all of us media folks. He represented the media in the Aurora Theater shooting trial. He's done quite a bit of work with the John Benet Ramsey case, the Oklahoma City bombing, even, and the Kobe Bryant. Never was a prosecution, but kind of the motions that went on down, fought for us quite a bit. Steve, do you have any takeaways from tonight? Any last comments?
My last comments is, your newsrooms are full of the younger generation. So as I look around the room, nobody would have raised their hand if I said everything on the internet's free and could be used without permission, right? But the younger and younger members of the newsroom do not take that for granted, and there's significant exposure there. So it's really behooves all of you in the media to make sure that the younger members of your staffs do not believe that everything on the internet is there for the taking.
Great point, Steve. And maybe you didn't know, Carl, I did look you up today, and I saw that you wrote a story called Being a Colorado Native is a Big Deal, so how many are there actually? So did anybody
Is there an answer to that?
Did anybody steal that idea from you?
No, but credit where credit's due. That was a Colorado Wonders question that came from a listener.
Oh, is that right?
And so we looked into it, exactly. And we
that.
chatted with the state demographer. My takeaway echoes what Steve said, which is, as a starting point, always assume it's not fair use, and you build from there. And if you can come up with the reasons why it is, great. Then you've got some grounding if you were to be challenged. Whether or not it holds up in court, that's the problem with fair use, is it's subjective to the courts. To the point of some of the questions, it's not black and white. So you have to have a basis of understanding about why you think it's fair use. And until you can get to that point, you need to err on the side of caution, especially now when we're in this 24/7 news cycle that never ends. You can't let that vicious cycle dictate what you do. You've always got to stay grounded. That would be my suggestion. And then, then you've done all the vetting that you need to do at that point.
Thank you very much, Carl. And Shane Anthony, our very own Nightcrawler.
One of the few.
This is
The
guy
scanners
who
are a
does
dying
who does
breed,
the
and so
real
am I.
work, folks. folks. Do you have any takeaways tonight, Shane? So good to have you on the panel.
Well, thank you so much for inviting me, Carol, and the panel's been great, and the audience has been great. The streaming audience is lovely out there too, I'm sure. No, I guess representing it from both sides. I mean, I've been involved in local and national newsrooms for decades, and I would just say, be on top of your game when you do post things or repost them or broadcast them, and do your best, as Carl said, to do your best to vet. That's all you can do. But from a content creation standpoint, I think I just stay vigilant and really guard your property, because something that's not of value to you today, as Dan said, in 10 or 15 or 20 years could really be of great value to you. So you want to keep on top of it.
You keep on going there, Shane. Good
Thank you.
luck. All right. Great panel tonight. Thank you so much, you guys. It's such a privilege to sit up here with you. Carl Bielik, Shane Anthony, and Steve Zansberg. Big hand for these folks. Thank you to the National Academy of Television Arts and Sciences Heartland Chapter, the Denver Press Club, and Julie. We've also got the Denver Media Center here. So thank you, everyone, and we're going to call it a night. Go Nuggets.